If you're a religious worker who left America after 5 years and you're watching this video from abroad right now, what I'm about to tell you in the next 60 seconds could be the difference between coming home next month or staying stuck outside the United States for years. On January 16, 2026, the Department of Homeland Security eliminated a law that forced thousands of pastors, imams, priests, nuns, and religious instructors to remain outside America for 1 full year after their R1 status expired. That 1-year exile is now gone. But here's the problem. Most religious workers have no idea what this actually means for them, who qualifies, what documents they need, or what to say when they land at the airport. And if you walk into a U.S. port of entry without understanding this new rule, a single wrong answer to a border officer can send you back on the next flight out and destroy your immigration record permanently. You didn't survive 5 years in America just to lose everything at the gate because you weren't prepared. So if you're a religious worker abroad right now, if your EB-4 green card petition is stuck in the backlog, or if you've been told you have to wait 1 year before returning, do not move. Do not book a ticket. Do not talk to anyone until you hear what I'm about to explain, because this rule just changed everything and the clock is already ticking. Let me be very clear about what actually happened. For years, the law said this. If you came to the United States on an R1 religious worker visa, you could stay and work for a maximum of 5 years. After 5 years, even if your EB-4 immigrant petition was still pending, even if you were waiting for your green card, you had to leave the United States and live outside the country for 1 full year before you could apply to come back. That rule destroyed lives. Churches lost their pastors in the middle of construction projects. Mosques lost their imams while their congregations were growing. Schools lost their religious teachers while students were still enrolled. Families were torn apart. Careers were ended. And for workers from countries like India, where the EB-4 backlog stretches 10 or 15 years into the future, that 1-year requirement wasn't just a delay. It was the end of their American dream. Then on January 16, 2026, Secretary Kristi Noem and the Department of Homeland Security published a final rule in the Federal Register. This rule officially eliminates the 1-year foreign residency requirement. What that means in plain English is this. If you are a religious worker who already completed your 5 years of R1 status and you left the United States because the law forced you to, you can now return immediately without waiting 1 year. You can apply for a new period of admission in R1 status even though you already used your 5 years. You can continue working for your religious employer while your EB-4 petition is still pending. And you can do all of this legally, officially, and right now. But before you celebrate, you need to understand exactly who this rule applies to, because there are 2 categories of religious workers, and the rules are dangerously different. Category 1 is ministers. That means priests, pastors, rabbis, imams, monks, nuns, anyone whose primary job is to conduct religious worship and perform religious ceremonies. If you are a minister, this new rule is permanent. It does not expire. It does not have a deadline. It is now the law, and it will remain the law. Category 2 is non-ministers. That means religious instructors, cantors, religious counselors, liturgical workers, catechists, workers in religious hospitals, or religious charitable organizations. If you are a non-minister, listen very carefully because this is where it gets urgent. For non-ministers, this relief is temporary. The rule was extended until September 30th, 2026. After that date, unless the government extends it again, the old restrictions may come back. That means if you are a non-minister religious worker, you have less than 8 months to act. You cannot wait. You cannot assume your employer will call you. You cannot hope that someone else will figure this out for you. September 30th, 2026 is your deadline, and once that date passes, this window may close forever. Now let me tell you what happens if you ignore this. If you are eligible to return under this rule and you do nothing, you will stay stuck abroad while your EB-4 petition ages out or gets administratively closed. Your employer may hire someone else to replace you. Your family in the United States will continue living without you. Your children will grow up not knowing you. And when the EB-4 backlog finally moves and your priority date becomes current, you may no longer have a valid job offer because your employer moved on years ago. That's not a scare tactic. That's what happens to people who wait too long. On the other hand, if you try to return without understanding this rule, without the right documents, without knowing what to say, you will be stopped at the port of entry. A customs officer will pull you into secondary inspection. They will ask you why you think you can come back. And if you hesitate, if you stutter, if you say the wrong thing, they will mark you as inadmissible and send you back. And that denial will follow you forever. It will appear on every future visa application. It will make it harder to return even if the law changes again. It will create a permanent stain on your immigration history that no attorney can fully erase. So what do you do right now? I'm going to give you the exact steps in the exact order. Step 1. Check your status before you do anything else. Go to i94.cbp.dhs.gov and pull your I-94 arrival and departure record. Find your R1 approval notice. That's Form I-797. Find your employer's petition. That's Form I-129. Check the dates. Confirm your petition is still active. Confirm your employer is still sponsoring you. If anything expired, if your petition was withdrawn, if your employer closed, you need to fix that before you even think about traveling. Do not assume everything is fine. Verify it. Step 2. Contact your religious employer in the United States right now. Ask them to write a letter on official letterhead. The letter must state that you are still employed as a religious worker, that your EB-4 immigrant petition is pending, that they are sponsoring your return under the January 2026 DHS final rule, and that they need you back to continue your religious duties. This letter is not optional. This letter is your proof. Without it, a border officer has no reason to believe you. Print this letter. Carry a physical copy. Do not rely on your phone. Do not rely on email. Bring the paper. Step 3. Consult an immigration attorney before you travel. I know attorneys are expensive. I know some of you cannot afford it. But this rule is only 2 months old. Some border officers have not been trained on it yet. Some will be skeptical. Some will try to deny you just because they don't believe the rule exists. If you can afford it, get a legal opinion letter from a licensed immigration attorney that explains your eligibility under the new rule, cites the Federal Register document number, and confirms that you are legally allowed to return. This letter is a shield. It shows the officer that you are not guessing. It shows that a legal professional reviewed your case. It makes them think twice before denying you. If you are a non-minister and your deadline is September 30th, 2026, this legal opinion is even more critical because after that date, officers may start rejecting people again. Step 4. Prepare your documents like your life depends on it. Put everything in a folder. Your passport, your R1 approval notice, your employer support letter, your attorney opinion letter if you have one, a copy of the Federal Register final rule from January 16, 2026, a copy of your EB-4 receipt notice showing your petition is pending. Organize them in order. Do not stuff them in your bag. Do not leave them in your suitcase. Keep them in your hand when you walk up to the customs officer. When they ask for documents, you hand them over immediately, calmly, professionally. You do not fumble. You do not search. You do not apologize. You show them you are prepared. Step 5. Know exactly what to say at the port of entry. This is the most dangerous moment. You are standing in front of a customs officer. They have the power to let you in or send you back. They are trained to look for hesitation, confusion, lies. You cannot afford to make a mistake. So I'm going to give you the exact script. When the officer asks why were you abroad, you say this: I was attending to personal matters. I am a religious worker, and I am returning to my employer in the United States. When the officer says, didn't you already use your 5 years of R1 status, you say this: Yes, however, under the DHS final rule published January 16, 2026, the one-year foreign residency requirement has been eliminated. My employer has an active EB-4 petition on file, and I am eligible to return to R1 status. I have supporting documentation. When the officer says, "Show me your documents," you hand over everything I just told you to prepare. Then you stop talking. You do not explain your life story. You do not tell them about your kids. You do not complain about how hard it's been. You answer their questions, and nothing more. Now let me tell you what not to say, because these mistakes will get you sent back. Do not say, "I'm not sure if I qualify." Never show doubt. If you sound uncertain, they will assume you're lying. Do not say, "My lawyer told me to come." That sounds like you're blaming someone else. Take responsibility. Do not say, "I overstayed before" or "I had problems in the past." Never volunteer negative information unless they specifically ask. And do not say, "Is there a supervisor I can talk to?" unless you are actually being detained. Asking for a supervisor too early makes you look like a problem. Stay calm. Stay confident. Answer their questions. Show your documents. And wait. Step 6. If the officer denies you or takes you to secondary inspection, immediately say this: "I would like to speak to an immigration attorney before I answer further questions." You have that right. It is not illegal to ask for it. It does not make you look guilty. It protects you. Do not sign anything until an attorney reviews it. Do not sign a voluntary departure form. Do not sign a withdrawal of application. Do not sign an expedited removal order. These documents have legal consequences that last for years. If they pressure you, if they tell you it's faster to just sign, if they say you can come back later if you cooperate, do not believe them. Say, "I need to speak to an attorney first." Then stay silent. Let me tell you why preparation matters more than the law itself. The law says you can return. The Federal Register says it. The DHS says it. USCIS says it. But the officer standing in front of you at the airport may not care what the law says if you cannot prove it. Immigration law is not automatic. It does not enforce itself. You enforce it by knowing your rights, carrying your proof, and speaking with confidence. The immigrants who get denied at the border are almost never denied because the law is against them. They are denied because they didn't know the law, because they panicked, because they couldn't explain themselves, because they looked unprepared. You will not be one of those people. You will walk in with your documents. You will speak calmly. You will show the officer that you belong here, and you will come home. Now let me tell you the mistakes people are already making and how to avoid them. Mistake 1. Assuming this rule means you can just show up without preparation. Some people think this rule is a free pass. It is not. You still need to prove eligibility. You still need valid documents. You still need to show that your employer is sponsoring you and your petition is active. If you show up at the border with nothing but hope, you will be denied. Mistake 2. Waiting for your employer to handle everything. Some employers are slow. Some don't even know this rule exists yet. Some are waiting for their own lawyers to advise them. If you sit and wait for your church or mosque to call you, you may wait until it's too late. Take responsibility. Contact them first. Push them to act. This is your life, not theirs. Mistake 3. Assuming your R1 is still valid just because you left recently. R1 status has a maximum duration. If you were close to your 5-year limit when you left, your status may have already expired. Check your I-94. Check your approval notice. Do not guess. Confirm the exact expiration date before you book a ticket. Mistake 4. Traveling without understanding the difference between ministers and non-ministers. If you are a non-minister and you think you have forever to return, you are wrong. Your deadline is September 30th, 2026. After that, this relief may disappear. Do not wait until August. Do not wait until summer. Start your paperwork now. Let me also tell you what happens after you return, because coming back is only the first step. Once you are admitted, you will be in R1 status again. That means you must continue working for your religious employer. You cannot switch jobs. You cannot work for a different organization. You cannot take a side job to make extra money. If you violate your R1 status, you will lose your work authorization and your EB-4 petition could be denied. Stay in status. Follow the rules. Wait for your green card. Your EB-4 petition is still pending. That means you are still in line. Your priority date is still active. When your priority date becomes current, USCIS will process your case, and if everything is in order, you will get your green card. But until that day comes, you must remain in valid R1 status. Do not let impatience destroy years of waiting. If your employer needs to extend your R1, they must file Form I-129 before your current status expires. Do not let it lapse. An expired R1 means you are out of status, and once you are out of status, everything falls apart. Work with your employer. Work with an attorney. Make sure your extensions are filed on time, every time. Here's the truth that no one else will tell you. This rule is a gift, but gifts don't protect themselves. You protect them by acting fast, preparing thoroughly, and knowing your rights better than the officer questioning you. Secretary Kristi Noem and DHS gave you an opening. They recognized that forcing religious workers to stay abroad for 1 year while their communities suffered made no sense. They fixed it. But they cannot walk you through the airport. They cannot answer the officer's questions for you. They cannot hand you your documents. That part is your responsibility. And if you take that responsibility seriously, if you follow every step I just gave you, you will come home. You will return to your congregation. You will reunite with your family. You will continue your work, and you will do it legally, safely, and successfully. If you are a minister, you have time, but do not waste it. Start preparing now. If you are a non-minister, you do not have time. Your deadline is September 30th, 2026. Contact your employer today. Contact an attorney this week. Get your documents in order this month. Do not wait. Do not hope someone else will remind you. This is your moment, and it will not last forever. Share this video with every religious worker you know. Send it to your imam. Send it to your priest. Send it to your congregation. This information could change someone's life. And if this video helped you, drop a comment below. Tell me if you are a minister or a non-minister. Tell me what country you are in right now. I read every comment. Stay legal, stay protected, and come home.